started. We have a form now. Good morning, Elliot. All righty. Let's see. First, we had last one is Senator McPike. You're next. We have our committee's attention to Senate Bill 1174. Good morning, sir.
Good morning, Mr. Chairman.
You would please tell us why we need your bill and what your bill does.
Absolutely. Thank you, Mr. Chairman.
And thank you for coming at 7 in the morning.
Love it.
That was 7 o'clock early-ish.
That's right. So what this bill is actually comes from a constituent, Mr. Chairman, who is a DCJS licensed canine handler in the private security. So he has the challenge of having obviously a very expensive canine that he uses for his work throughout the Commonwealth and in the private industry. He is not afforded the same tinting ability to keep the inside and interior of his car cool. And obviously for a canine, they're working dogs, their temps run hot. To cool off inside this car is very difficult. He's invested, like many canine handlers, they have automated sensors within them, they have windows that will drop at certain temperatures, but really keeping the interior surface of those vehicles is extraordinarily important to keep the temperature of these vehicles cool for these dogs. So that is the intent. It provides an exemption for those who are licensed by DCJS as private security for a canine handler. And so there's an existing framework and license for this. This would provide that carve-out to allow that to take place.
All right, sir. Members have any questions? Anything? Someone in the audience to speak in favor of Senate Bill 1174? Yes, sir. Young Watson.
I do have a question. Are these cars specially marked in any way? I mean, would I know if what it was or who it is?
You would likely not, for reasons. Some of them do have markings, others would not. Due to the nature of their work, they wouldn't necessarily advertise it depending on the client that they're working for. This debate came up also on the other side with Chairman Carrico in his experience with state troopers. The question was, would you get additional pullover, unintentional pullover? He said, well, you might, but it's likely infrequent. And the person would just show them their DCJS license and exclusion would apply to them.
Don Thomas.
Thank you, Mr. Chair. So I'm looking at paragraph M, and it talks about, the tinting rule shall not apply while in the performance of the private security duties. Is this like a regular personal vehicle, and spouse might drive it at times, and when it's not in the performance of actual duties, is it then out of compliance? Just trying to figure out how it would be used in that situation.
So these vehicles are specially equipped. You really don't use, number one, these type of dogs are fairly expensive. You're talking about tens of thousands in some cases. So the vehicles are usually adapted with not only the back cage portion redone, reconfigured, it's sort of custom configuration, as well as temperature sensors. Some of them will notify your cell phone in case you've got the car running in a way, something happens that the AC drops. They're fairly sophisticated. So this is not the average run-of-the-mill vehicle.
Any further questions? I'm assuming there's probably, how many licensed?
Yeah, I don't know the quantity. It's a very small quantity.
Half a dozen in the state or
Yeah,
something,
that's right.
probably?
That's
Something
right.
of that sort. All right. Anyone in the audience to speak in opposition to Senate Bill 1174? Where's the good? Oh, you guys in the back. You guys are good? Somebody riding down the road, got really darked out windows. You guys are good? Not pulling them over. And
Mr. Chairman, Ron Maxey, Virginia State Police. I believe some of the concerns are true. It's going to be very difficult for us to enforce and verify the actual in-performance, but we have no concerns with it. But the enforceability of this is going to be problematic for the department and law enforcement.
And Captain or Senator McPike, so they could literally blacken out the windows then. If you're getting rid of all the tinting, the 15% of the front, 35% of the back, you could basically make it 100%, correct?
The way it is, there is no limit on that.
Correct. Doug and Rob.
So I appreciate the intent of the patron, and seems like a practical way to address the situation. The question that comes to my mind is that when I'm approached, we'll say, by a constituent who has a pet who they consider to be like a family member, I don't think that's altogether uncommon, and they say, well, if we allow this for security dogs, why would it not be allowed for any
Chairman, I'd respond to the delegate that these are contexts where the dog is in the vehicle for, usually it's working day. So whether it's a hot August day, this is a continuous utilization of this working animal. And so it is a little different context where you're not just bringing your pet to a neighbor's house in the car and transporting it. This is a continual part of the dual job of the security handler as well as the canine itself.
All right, any other questions? All right, and no one's in opposition of this, okay. Measure rests with our committee.
Move report, Mr. Chairman.
Second.
We properly moved and seconded that Senate Bill 1174 be reported. Members to vote on the electronic voting record. There you go.
Thank you, Mr. Chairman.
Motion report advance on a 7-2 vote. I don't know that you necessarily need to be at our full committee on, is that our last committee meeting on this Thursday? So you might want to be there just in case some of these other questions come up, but I suspect you probably got most of the questions that everybody could think of. Thank you, sir, very much.
Thank you, Mr. Chairman.
Senator Black, I think you're next on our list, sir. Draw the committee's attention to Senate Bill 1154, and I believe we have an amendment, sir?
Yes, we do.
All right.
Yes, sir. Chairman, ladies and gentlemen, what this bill does, we have a rather unusual structure to our reckless driving statute. What happens right now, of course, when we think of reckless driving, something comes to mind of somebody who's just, tearing down the road, hitting curbs and things of that sort. However, the problem that we have is that
Senator, I don't mean to interrupt you, but I just want to make sure everybody's had a chance to look at this. In essence, what he's doing is striking lines 13 through 15 of the introduced bill and basically just now introducing a new section that's better to avoid a collision. Do you understand? All right, by general consensus without objection, this is properly before us as substituted. All right,
Yes.
sir, sorry to interrupt you, sir.
And I'm sorry, and I'll just add to what the chairman mentioned. There was some concern about kind of a void for vagueness notion with the first provision that we had originally had. So this eliminates that concern of the committee. So what you have is, right now, you'll have a very minor accident. For example, somebody, let's say you have someone driving down the road and one of the children acts up a little bit and they say something to them. The next thing they're suddenly up on somebody, they hit the brakes and they have an accident. They're doing 1 mile an hour, but they have a little bump. By law, the deputy or the police officer is required to charge reckless driving, and then the individual is forced to go into court with the possibility of up to a year's confinement, $2,500 fine. They go in and naturally they're going to get an attorney because they're concerned about the ramifications of that. And they go in and their attorney says, Your Honor, this really was just a very minor thing. It was, a little inattentiveness, certainly some error on our client's part. And at that point, and only at that point, is it possible for the judge then to say, okay, we're going to reduce this to improper driving and give a fine. Meanwhile, we've tied up the deputy in court. The deputy's been taken off the road where they could be doing good things. We forced the individual to pay out a lot of money that was unnecessary, and we've also clogged up the court. And so it's just an unnecessary step. A number of counties have responded to this by passing ordinances that have some lesser offense something that is not reckless driving. Now we, in Loudoun County, we were going to do this. We asked the Attorney General, is it lawful? He said, no, under the Dillon rule, it's not. So we do have a number of counties that are operating. It works, but it's not legal, and we just don't do that in Loudoun County. So the sheriff and now the Commonwealth Attorney have worked very hard, and they've come up with solutions. The biggest single problem is where you have a rear end collision, a very minor one, and we think this failure to avoid collision takes care of probably 85–90% of these. Basically it's to unclog the courts, to save people money, and to get our deputies back where they should be. I do have one of our deputies here who would like to testify.
All right, so any members have any questions of the patron? Delegate Adams.
Thank you, Mr. Chairman. Senator, my first thought when I see the text of this language is there already exists a common law, or probably elsewhere in the statute, a duty of care, and that's the initial language that you have here. The driver of a motor vehicle shall exercise due care. Would you agree with that?
Well, what I'm told by our Commonwealth's attorney and by our sheriff's department is that there is always a duty of care in a civil context. There's no doubt about that. But in terms of the traffic laws, we don't have a specific provision that deals with that. That's my understanding. And that's what forces the deputy to charge reckless, and perhaps if we hear from him, he can better explain that.
All right, sir. Yes, sir. Come on forward. If you would please identify yourself and give us your testimony. Good morning, sir.
Good morning, Mr. Chair. Thank you very much. On behalf of Sheriff Chapman, thank you for allowing me to speak this morning on the importance of this bill. My name is Mark Poland. I'm the Chief Deputy with the Loudoun County Sheriff's Office. When I think of this bill, I can't help but think back to the early 90s when I was patrolling a sector and responding to accidents, especially those that I did not witness. And so many times, as the Senator mentioned, so many times when I didn't witness the accident, I was forced to write a reckless driving charge for the citizen. Now, that doesn't mean that the citizen still isn't culpable for their actions. However, in my professional experience, in my professional opinion, it didn't quite rise to the level of reckless. What I could do at that time, and what it's changed now, but what I could do at that time, I could actually write on a Virginia uniform summons under reckless. I could put in parentheses, I could write improper, and essentially that would signal the judge that, in my opinion, I'm looking at, hey, I think this is they're still at fault, but this is obviously a little bit lesser offense. In my opinion, Sheriff Chapman's opinion, this really provides the deputy, the guy and gal on the street, one more tool on their tool belt to charge, still hold people accountable, but to charge a little bit lesser of offense, something that may be prepayable. Does not mean that at times we still won't charge reckless. It depends on the incident, depends on the accident, the evidence in this witness states. But for the most part, at least in my experience and for many deputies, the majority of these are a lesser offense. We still charge reckless at times, and we still, are very successful with that. However, this will just really add one more tool for guys and gals on the street to charge probably a little more appropriately, and proceed with court. We can't write that on Virginia summons now because many jurisdictions like Loudoun, we've gone to the e-ticketing system, and there's not that component for that officer on the street to kind of signal the judge, hey, this is where I'm going with this case until we get to court. Thank you very much. This is an important bill. We support this in many ways. Under the Virginia Sheriffs, Virginia Chiefs Association also support this bill, and I appreciate the time.
Any questions? Deputy Poland, thank you for your service. I think I speak for everybody up here. You don't even know who any one of us was when you chose to put that badge on your chest and defend each one of us, sir. We thank you humbly for that, sir. Yes, sir. Come on forward, John.
Good morning, Mr. Chairman and members of the committee. I'm John Jones, representing the Virginia Sheriff's Association, and we do support this bill. We hope to pass it.
Thank you very much. Yes, sir. What say at the bicyclists?
Mr. Chair, we support the bill, thank you.
Figured. All right. Anyone else in support? Anyone in the audience in opposition to Senate Bill 1154? Sir, what say it? You guys?
Mr. Chairman, Ron Maxey, Virginia State Police. We're in no position on the bill as written. There is the possibility here that it does place a burden on someone on the roadway if someone else commits an illegal act. This code could possibly hold them, especially in a civil situation, liable for running into that vehicle, even though the other vehicle maybe was the one committing the act which caused the accident. Other than that, we have no concerns.
You actually lost me on that one. There's too many actions to the actions to the actions.
The only concern here is there are multiple charges that can be placed outside of reckless driving in a situation where you do have to yield right away. Here it's saying that the driver of the motor vehicle shall exercise due care and increase the speed of the vehicle as necessary to avoid colliding with any person, vehicle, or other conveyance on or entering the highway. This does not specify if that vehicle was maybe doing an illegal act. You run into it and it could hold the person that was well within their rights, traveling, doing the exact correct thing they should. An accident's caused by somebody else doing something illegal. This does not allow any leeway, and it could result in something in court that could place some burden on the person that had no fault in the accident, other than the fact that they did collide with other vehicles.
So someone's parked on the shoulder and decides they want to get back in the lane because for whatever reason they pull in the lane and it really wasn't safe to do so. The car, dutifully, lawfully traveling, collides with them, and now they would be at fault under this statute.
Correct. That's the vagueness we can see possibly in this, is that it does not allow for anything other than that. It's just requiring the operator of the other vehicle.
Hey Scott, what do you think? I got my two lawyers. I got one lawyer here that knows all the civil stuff. I got two guys that are in this space. Yeah.
I'm not.
Yeah, I'm with you. I'm with you. Delegate Laura, I understand you, but I'm going to use what I got in the audience. Delegate Laura, yes, sir.
Some people might speculate that this would reduce the amount of business that lawyers have. So
I don't think that's a speculation. I think this is an anti-lawyer bill.
That might just be worth taking into consideration. Since we have Mr. Holcomb with us here from DMV, I forgot your proper title, Commissioner Holcomb, could you perhaps just comment on the effect this would have on the driver's license, revocation, number of points for reckless, what is before us, and then I guess distracted driving would be the next increment below that? Thank you.
Good morning, Mr. Chair, members of the committee, Ellison Ford, DMV. The reckless driving, if that conviction we were to add to the driving record, that would be 6 demerit points, and proper driving is 4 demerit points. Other than the number of points, that would be the only distinction. In some cases for reckless, we might expect to receive a suspension in conjunction with the reckless driving.
Delegate Laura, yes, sir.
And so failure to avoid a collision, what would there be points for that? For this law, for the proposed laws before us?
That would be typically whenever the legislation is passed regarding new convictions, then the commissioner has the discretion to determine whether it's going to be a serious, moderately serious, or less serious conviction, and so that would depend on whether it's 3 points, 6 points, or 4 point demerits. In this case, it may be this would be a 4 point or a 3 pointer.
Thank you.
Delegate Watson.
Mr. Chairman, I think as far as the state troopers are concerned, I think when you read the words due care, if we are, let's say you do have a situation where someone does something and it's not actually the fault of the individual who collides, I think the judge would look and say, well, he was exercising due care. And so it's not his fault. You have to exercise due care. He was exercising due care. There was a collision nonetheless, but that is an element of the offense, is that you would, I think you would have to show that there was a failure to exercise due care before you would have an offense. So I think the wording here is sound, and I think it would be a tremendous benefit to the public and to the court system also.
All right, Delegate Bloxham and then Delegate Toscano.
Mr. Chairman, I'm just trying to figure out, I guess this is a question for counsel. I'm trying to figure out the difference between what he's trying to do and the way the code section reads now, because it's following too closely. Looks like to me covers what we're trying to do, right, with this additional language.
Yeah.
Mr. Chairman, Delegate Bloxham, just because I think that this bill is meant to address a situation where there's the Commonwealth or the police officer has not witnessed the incident, and so there's not proof that the accident was a result of following too closely. So this would give something else that could be charged if there is a collision and there's not proof of how that occurred.
All right, Delegate Toscano.
Thank you. I have a question for the officer.
Deputy Copeland.
Yes, sir. Thank you. Yes. So, do you have to charge every time you come upon a collision?
No, sir. We do have discretion. And one point, I guess I would argue with the Virginia State Police. I completely understand that perspective. However, in a multiple incident crash, this bill would not apply. You know, multiple incident crash, we have 5 or 6 car pileup. You know, the police officer, the deputy, is still going to investigate that completely and charge appropriately, and that may very well be reckless driving. This bill definitely covers a vast majority of the accidents that we encounter on a daily basis that are 2-car accidents, rear-end collisions, very minor damage to both cars. And where we're handcuffed, for lack of better terms, is the ability to charge anything other than reckless because we didn't witness it.
Yes, sir. Delegate Toscano.
Why do you have to charge it all?
We don't.
So,
Yes, sir.
why do you say this doesn't apply to multi-car accidents? It doesn't say anything about multi-car accidents and any exclusion.
I guess I'm just speaking in reference to the example that the trooper was providing, looking for a loophole in there. But you know that it's what we're trying to establish is just one more tool for these guys and gals to be able to charge appropriately, given the circumstances of the incident or of the event.
Yes, sir.
So here's what I'm struggling with, and I think a number of attorneys would struggle with it too. This thing is so vague that it allows, you can charge for any of it, and for the most part, if somebody gets charged with this, it's a small fine, they'll probably just pay it. But it could be a lawyer relief act, because any lawyer would have a field day with the statute in court. How are you going to determine whether somebody has exercised due care in decreasing the speed of their vehicle? You didn't witness it, you didn't see it. You could have somebody say, well, you know, in your case, the car pulled out in front of me and I hit it. I mean, that would be probably grounds to dismiss the case right away. So if you talk about clogging the courts, this is more likely to do it. Not only that, but I think there's a concern of mixing up the civil liability stuff with the criminal law. I don't use criminal law at all, but I'm not sure if you were to take this to courts and you were to take this to courts and ask them how many times you see the word due care in the criminal code, I don't know how frequently you see it. So I have some concerns. I do think it applies to multi-car crashes because there's no exclusions. And I have some of the concerns that the state police evidence when they were here.
All right. Other question? Yeah, Delegate Rock. Yes, sir.
I guess this is more of a comment, but when I had comments that the delegate from Charlottesville has just made, I think, apply to that as well. And I'll just read that very briefly. Irrespective of the maximum speeds permitted by the law, any person who drives a vehicle on any highway, recklessly or at a speed or in a manner so as to endanger life, limb, property, etc. That's wide open to interpretation there as well, I think. So for purposes of anticipating how a court might have a heyday or not interpreting a law, I don't think that the law that's before us is proposed is any less vague or than the reckless that we're, I think, trying to we're not trying to do anything to reckless. We're trying to provide an increment that is perhaps less severe than reckless.
Mr. Chairman, I'm very much in agreement with that. I think the words, again, the words "do care," the judge is going to have to make a decision. I mean, you think about the word reckless. What is reckless? Reckless is if there is a judgment that something is not within the norms for driving and is well beyond the norms for driving. Due care is less than the term reckless. I mean, this is just, it's applying the English language. Now, I will say that this statute has been very carefully drafted by our Commonwealth's attorney with his office. He has one of the major offices in the state, and I think he may have been the head of the Commonwealth's Attorneys Association at one time, Jim Plowman. So it's not something that was thrown together by me or someone else, but this was very carefully drafted over a period of time.
All right, so Jeff, did you have something quickly, because we've got.
Briefly, Mr.
Yes,
Chair.
sir.
And the senator just hit on it. I just wanted to reiterate the fact, Jeff Gore, Loudoun County, reiterate the fact that this language was hammered out after many lengthy discussions like you're having now with the Commonwealth's attorney, Mr. Jim Plowman, and Sheriff Chapman, and the county attorney. Senator Black started off by letting you know that it is a fact that counties and localities around Virginia have adopted ordinances that essentially allow this. We have an AG opinion that says that violates the Dillon rule. Not that the concept is flawed, but that local ordinance violates the Dillon rule. And if there were authority for that, then it's in line with the law. So all the bill really does is conform current practice in many jurisdictions, many large jurisdictions, with the law. And it gives, as the deputy said, it gives them another tool in situations where it clearly, when they arrive on the scene, doesn't warrant a reckless charge. I think this is good policy for the Commonwealth, and urge your support.
All right, sir.
Quick question.
No, that Rob.
Thank you, Mr. Chairman. So effectively, we have a variety of Dillon rule violators who provided us with a pilot program. As far as you know, has there been a manifestation of the concerns that have been expressed here? Are the courts clogged with cases that are trying to sort through ambiguities or whatever?
No, to our knowledge, and I won't recite the counties that are involved. There are 13 counties that are operating with similar ordinances, and there's not been a problem. It's worked just fine. It benefits the courts, benefits the sheriffs or police, and it benefits the individual. I'll tell you, one of the things that is killing us in this state is we have a structure in our courts that takes people who do not have a lot of money and it drives them through a system. We burden them with court fees. We require them to pay for the whole court system. And a lot of times these are people who are clinging on by their fingernails. And in this case, this is where we can actually do some good, and we can say, you know what, there's no reason for these people to, you know, shell out a couple $1,000s for a lawyer when all he's going to do is walk in and say, Your Honor, in this case, the degree of culpability is slight, and so under section 46.2, 869, we think that improper driving is the appropriate offense. That is a lesser included, but it can't be charged by the deputy. It has to be done in court. So you drive these people in court, you force them to pay money unnecessarily, and you clog up the system, you take the deputies off the road. The whole system is not working well, and 13 other counties have recognized it and said, we got to do something about it, Dillon rule or not. And that's not the way we should function. We should, and Loudoun County wants to function according to the Dillon rule. We want to do it lawfully, and that's the reason that we've very carefully and very thoroughly worked on this.
All right, Delegate Toscano, did you have another question?
Just one quick question. How much is the fine for this and where would it go?
I think what you apply, yeah, Emma.
I'm not sure what the fine is.
Emma knows.
Mr. Chairman, this would be a traffic offense punishable by no more than $250. That actual fine would be set by the Supreme Court in the Uniform Fine Schedule. For context, following too closely is a $30 fine, 51 in court costs, so 81 total.
Yes, sir.
Well, where does it go?
Goes to the literary fund.
All right. I think we've got, you guys have done a masterful job. I have only one attorney up here. Two attorneys up here. Yeah, oh my Swiss cheese. All right, members.
Move to report. Substitute motion, Mr. Chairman.
All right.
Motion to PDI. And at the appropriate time, I would like to speak to it.
All right, we'll get 2 minutes.
Second.
It's been probably moved and seconded that Senate Bill 1154 be passed by indefinitely. Each side has 2 minutes. Why don't you talk first and give him the last word?
Certainly. Well, Mr. Chairman, and with respect, Senator, and certainly understand the intent of the bill, but for the numerous reasons that have been brought up, I think it would be ill-advised for us to make this law. You know, number one, it does confuse civil and criminal concepts, as Delegate Toscano pointed out. Two, I suppose, you know, by the admission of the officer is going to result in increased charges where, in some cases, we don't need a charge. We also, as the state police mentioned, have, be following too closely, a statute and others that can be given in particular situations. And so, you know, I think there's a compulsion that, well, we have an accident, we must have a charge, and that's not necessarily the case. But in this case, the way this is drawn so broadly, vaguely, you know, you could foresee someone being charged with reckless driving and another person also being guilty under this statute at the same time. And I just think that's moving away from a very extensive body of law that we have in the Commonwealth under reckless. And that would be my last point, because I think that was raised about, well, what do these words mean? Well, you know, that has been litigated for a long time, and there's a lot that is relied upon in the courts under, you know, what those terms mean. And so, based on my experience and those different points, that's why I made the motion respectfully.
All right, sir. Senator Black.
Well, a couple of things. The notion that this sort of intermingles civil and the criminal or infraction law, I don't think that is valid at all. I mean, the civil law is independent. There has to be certain elements of proof under civil law. You can have a totally distinct civil action. The fact that in some cases offenses need not be charged, that there's prosecutorial discretion at all levels in all cases. It's always there. And I think the fact that we cite due care if you think of it, there is no statute where words do not have meaning and where there's not a level of culpability. Reckless, the term reckless, what I consider reckless, what somebody else considers reckless, may vary slightly, but not tremendously. And I think what I view as due care and what each of the members views as due care, it's always going to vary slightly, but it's going to be relatively in the same ballpark. It's the nature of drafting these things, and in any event, I think the benefits of this to the public, to the system, are tremendous. If it were not the case, you wouldn't have 13 jurisdictions, some of them very major jurisdictions, that have said, hey, look, if the General Assembly will not help us with this, then we're just going to do it, because we're just not going to put people through this anymore.
All right, sir. All right, members, you have before you Senate Bill 1154, the motion to pass by indefinitely. Members would vote on their electronic voting record. Motion to PBI passes on an 8-1 vote, sir. All right, thank you very much. Senator Deeds, you're next, and then Senator Turble, you're on deck, sir. Yes, sir. Good morning, sir.
Morning, sir. I've got Senate Bill 1487.
If you would tell us why we need your bill and what it does.
Okay,
please.
what the bill does, it requires DMV at the request of an applicant for a driver's license to, and the presentation of a signed statement from a neurologist, confirming the applicant's condition to put the designated traumatic brain injury on the applicant's driver's license. Here's the application right now. Circle here is where you make a certain designation. Well, as a matter of code, we allow insulin-dependent diabetic, speech impairment, hearing impairment, intellectual disability, autism spectrum disorder on a physician's certification. We've allowed those to be designated on driver's licenses already. The idea is to give the officer information about the person when a person stopped or going through a road check. This was brought to me, I was visiting with a brain injury group in Charlottesville. And often brain injuries, which often occur as a result of car accidents or however, they result in a person's inability to communicate effectively. They've got a speech impediment, or they can't walk very well. They've got some lack of coordination. This was requested by folks in that group and some of their counselors, basically as a way to give the officers more information when they were stopped or when they went through a road check.
Right. Members have any questions? Yes, Delegate Thomas.
Thank you, Mr. Chairman. So I assume most of these people are probably receiving treatment. I know there's a lot of treatment research and stuff going on because it's a prevalent problem. Is there at some point, maybe when they renew their license, do they have to show that again? Because at some point, hopefully, it'll be fixed.
Well, and sometimes it can be fixed, but lots of times when there's a traumatic brain injury, there's no fix. They've got to present a neurologist, a certification from a neurologist. And we don't require that of any of the other conditions we already listed. Insulin-dependent diabetics, people with speech or hearing impairments, intellectual disability, autism spectrum disorder. We just require certificates from doctors. I think there's some discretion with DMV to require further certification if there is if there's the condition no longer exists.
All right, we'll get y'all up in just a second to that. Senator Deeds, my only question is all the other current allowances that can be placed on have a degree of permanency associated with them. You're not going to change from being an insulin-dependent diabetic mellitus, diabetes mellitus to normal. You're not going to change from you can have degrees of autism, but basically when it's traumatic brain injury, and it's sort of to Delegate Thomas's point, technically, your high school football quarterback gets tackled hard, gets dinged, he's got a concussion, he's sort of dazed for a couple days, he's had a traumatic brain injury. Is there any qualification that and I get the intent of your bill, sir. I think if there's some degree of permanency to it, but that isn't, as I understand, what this would be doing.
Well, if the Chair, if you want to amend the bill to require permanency, that's all right with me. With the workshop that I visited, I think most of the folks have permanent insurance.
Sure. All right. And, all right. Is there anyone to speak? Thank you, sir. Any other questions? No. All right. Is there anyone in the audience to speak in favor of Senate Bill 1487? Yes, ma'am. Keep going forward.
Morning, Mr. Chairman.
Morning.
Becky Bowers, I'm here with the Brain Injury Association of Virginia. We're in support of this bill. I think this is permissive. I have insulin-dependent diabetes. I don't have a permit for my, or an ID for my driver's license, but when I started looking at this, I thought, that's probably a good idea. Because sometimes we don't wear anything that identifies ourselves as having a medical condition, and if something were to happen that caused some kind of accident, and then there were some sorts of behaviors exhibited by the driver at that time, it would be helpful to have that on their license. It's not required. Permissive, again, people with traumatic brain injury who are at places like the clubhouse at Bridgeline and in Charlottesville pretty much have a permanent disability. But other than that, there are some who do recover, and I would assume then that they would choose not to have them on there.
All right. Anyone else in the audience to speak in favor of Senate Bill 1487? Anyone in the audience to speak in opposition to Senate Bill 1487? All right, and Commissioner, how would you address Delegate Thomas's concern? So somebody re-ups in 8 years and their traumatic brain injury has thankfully resolved.
Good morning, Mr. Chairman, members of the committee, no support with DMV. Typically with the indicators that already exist, DMV does not require that they present another statement on their behavior like it. So if they place an insulin-dependent diabetes indicator on their license, first time they got it, it would continue unless that customer requested it be removed. And so in this case, it would apply the same.
And Senator, one other question I had. So there's plenty of counties that don't have a neurologist that live in the entire county. How do we deal with the folks down country?
This bill didn't initially require neurologists. That was an amendment placed on the bill in the Senate. And I agree with you, but I would assume that most people that are diagnosed with a traumatic brain injury are going to receive that probably at a hospital from someone who has the ability to make that diagnosis. This bill is about providing the officer more information, and it's purely discretionary. The applicant doesn't have to seek it. And frankly, even this designation does not prohibit the officer, if there's probable cause to investigate some sort of crime, from investigating the crime. I mean, this is just about providing the officer more information.
All right, sir. Questions? Emma, can you give me a comfort level with this concept of permanency, and if we were going to amend it, as the senator is suggesting, you might be amenable to, what would it sound like or look like?
Mr. Chairman, the change would be on line 66 after injury. Insert that is likely to cause a permanent impairment to the applicant. So as a whole, it would read that the department shall indicate on the applicant's driver's license that the applicant, switch forward to Romanet 3, has a traumatic brain injury that is likely to cause the permanent impairment, or a permanent impairment to the applicant.
Love it when I see all these brains just whirling up here. Just a thought, you don't have to do it, that's just mine, that was mine.
I just want to make sure it's friendly to the patron.
I don't have any problem with that. Most the people that presented this to me are probably, for the most part, they've got permanent injuries.
Right.
These are people that can do a lot of things in life. They just struggle with communications, or they struggle with the gait. And this is just about providing the officer with some information, help explain what's going on with them.
I would move the line amendment.
I'll second it since I introduced it. I don't know if I can, but I will. All right, without, you all right? Dustin, okay. Yep, without objection by general consensus, it is as amended. Yes, sir.
I do have one more question out of curiosity. I know we're talking about the officer, but if there's an accident, does an EMT typically look? Because this might give them some information as well.
It may, but I don't know whether they're going to look.
Right.
Well, they may when they try to figure out who they're dealing with.
Right. Might help there.
Yeah, Senator, I just don't want us to establish yet another Christmas tree so that, I have coronary artery disease now, we're gonna have that I've had a previous heart attack, coronary artery disease on my driver's license, or I have this disorder. Every other disorder can be delineated on your driver's license. That would probably create a huge tsunami.
And I'm thinking about 2014 or 2013, we added a couple more of these conditions
Yes, sir.
to the app. This is about things that may explain why the driver is doing what he's doing, or what's. If you think about it, these conditions are already here. May explain what the seizure is about, what the driver's doing. That's all the TBI is too.
All right, sir. All right, members have any questions? Delegate? Ward, yes, ma'am.
Just one question. Your list of those diseases, is it all inclusive and nothing else would fit in?
Well, these are the conditions have all come in by statute. I don't think DMV's put any of these voluntarily. I don't think DMV's authorized to do it unless we tell them to. So these have all come in by legislation. Yes, ma'am. So the 5 or 6 things I've listed plus this would be all that would be on the application.
All right. All right. This member, I think, measure rests with our committee. We have a motion? We probably moved and seconded that Senate Bill 1487 as amended be reported to the full committee. All right, the members will vote on the electronic voting record. Measure report is amended and passed on a 9-0. Senator, you do not need to be at our full committee meeting. Thank you very much, sir. Senator Serval, you've been extraordinarily patient, sir. We thank you for your patience. Draw the committee's attention to Senate Bill 1550. You would tell us why we need your bill, sir, and what your bill does.
Sure. We need the bill because I've been hit by cars 3 times riding my bike. The bill does 2 things. First of all, it makes it clear, at the bottom of the very last lines 35 and 36, make it clear that you cannot use a bicycle lane to pass a vehicle on the right. The second part of the bill creates a new infraction for causing a serious injury to a vulnerable user. The first one I'll address really quick because that's the easiest part. But, many of you probably noticed driving in Richmond, bike lanes are proliferating everywhere. Not just in Richmond, but many of the sort of urban areas, college towns, etc. And the reason is we're trying to separate cars from vehicles. Bikes from vehicles, because bikes go slower. And with these new lanes, you find that a lot of people are not really fully understanding the dangers of driving a car in one. So a lot of times in a car that will stop at a left turn, people will queue up behind them, and instead of waiting, they'll use the bike lane to pass everybody on the right. But nobody ever checks the right to see if the bike's coming from behind that they might run into. And you're not supposed to have bikes and car lanes. And some law enforcement agencies say that it's not clear in the code whether or not you can use a bike lane to pass on the right. And this would make it crystal clear you can't have a car in a bike lane, period. Now, you can't use the bike lane to turn right. You can use the bike lane to turn into a driveway. If you look, just pay attention. Some of the bike lanes actually have dotted lines where these turn maneuvers are permissible, so that would be okay. You can't use a bike lane to pass a car that's stopped, is basically what this would do. The state police made a request for some additional language for exceptions, which we included in the bill. The other piece is what's called a vulnerable user law. This came to my attention, I think, about 5 years ago. I went to an NCSL conference in DC. They had an all-day conference on bike and pedestrian safety and vulnerable user laws. There's a program going on nationally called Vision Zero, which is about reducing the number of pedestrian and cycling fatalities. In Virginia, the DMV gave me data a couple of days ago that showed that since in the last 5 years, pedestrian fatalities in Virginia are up by 30%. In 2014, 90 people were killed on the roads. Last year, 120, I think. 130, 120 or 130. I forget. I have the spreadsheet. Nobody wants to see it.
But pedestrian fatalities are up in Virginia, they're up nationwide. Same thing with cycling injuries, fatalities, and accidents, because more and more people, especially millennials, are shunning cars, transit-oriented development, etc. And so what other states have done in response to try and quell the rising number of people getting killed and injured is pass these vulnerable user laws. And you heard a little bit of this discussion under Senator Black's bill a minute ago, but basically the problem with reckless driving when it comes to pedestrians and cyclists is that Virginia has this case called Powers versus Commonwealth, which was the Supreme Court came down with in 1970, where the Supreme Court basically said that merely because you have an accident and somebody gets hurt really bad, that doesn't mean it's reckless driving. And you have to prove the manner and nature of the accident, exactly what the driving behavior was, what the victim was doing, in order to convict somebody beyond a reasonable doubt of reckless driving. And the problem this presents in terms of cyclists and pedestrians is that when a cyclist or pedestrian is struck by a 2,000-pound plus vehicle, the physics don't work out very well. And many of the pedestrians, cyclists end up concussed. They can't remember what happened. All they know is they're walking or they're riding and they woke up in a hospital or they're dead. So you typically lose that, not typically but often lose that witness to the incident. The driver, the other vehicle, either says, I didn't see him, which is what you'll hear from the cyclist in a minute, is what they always hear, or they claim out and don't say anything, and under the Fifth Amendment you can't make them testify and there's no other witnesses. And so under Powers, you can't hold somebody criminally culpable for causing these scenarios. And so what the bill does is that only in scenarios that involve vulnerable users, which is defined as a pedestrian, cyclist, and there's a couple other things like people on foot scooters and things like that, if somebody receives a serious injury, which is defined in the malicious prosecution statute, we're not talking about, oh, my back hurts or I sprained my wrist. It has to be something where you've got a broken bone or there's blood, like a lot of blood, not just a scratch, but it has to be a serious injury that would fit as malicious wounding. There would be a lower criminal, I probably shouldn't say criminal because it's just a traffic offense. It's not a class 1 misdemeanor, it's only a traffic offense. There'd be a lower standard to get you in the door for culpability on the traffic court side of things. And what we framed that as in the bill, which is what other states have done, is careless or distracted. Distracted is a criminal concept. In fact, the House of Delegates passed a bill about distracted driving last year. Delegate Collins, the variant of the hands-free bill, before we amended it in the Senate, then it went to a Commerce Committee, didn't pop out, used distracted as a touchstone for culpability. Careless is more of a negligence concept. The committee wants to strike out carelessness because of that. I'm happy to do that. It's just seriously injure a vulnerable user in a distracted manner. I think that works probably just as well. But we do this already in the code in lots of places. We have different rules for law enforcement pedestrians. We have different rules for construction workers. We have different rules in school zones. We have lower thresholds to reach things. We've passed a couple laws out of the Senate this year about using cameras to catch people in these scenarios because these kinds of people weren't at risk for getting injured and killed. And so this bill is just a different sort of play on that. And I can get into data if you want to get into data, but I'll just say in closing that I kind of mentioned joking at the beginning, but I've been struck by cars 3 times riding my bike. I rode my bike across the United States between law school and when I started practicing law. Rode 5,000 miles across that summer, about 1,000 of them in Charlottesville training, and then about 4,000 miles across the U.S. And I got back to work, and the second time I got on a bike in Northern Virginia, some idiot cut me off, and I tried to tackle him at about 30 miles an hour because he said he didn't see me. And you know what? He didn't get convicted of anything, even though there was a witness. So, huh? No, I wasn't charged, but I got a grade 3 separated shoulder that didn't put back together, which I can show you if you want to feel the lump in my shoulder. It's still there because of it. And I was hit 2 other times because people, a lot of vehicle drivers don't look for bikes, and it's a real problem. So that's why I put the bill in. I think this is the 2nd or 3rd time I've tried it. It's come out of the Senate once. Last year it did. This year it came back out finally. So hopefully you guys will favorably considered. I'm happy to answer any questions.
All right, Delegate Thomas.
For a moment there, I thought my worst nightmare came true. The speaker put me on course committee. I'm not sure what's going to happen to the bill, but if it does pass out of here, I would assume that somebody on course is going to have to listen to this because everything you just said there went way over my head. So I think if we're looking at the transportation part of it, I would just suggest that if we do report, we better refer this over to courts.
This was, as you all recall, we've heard elements of this before. The first half of this provides the use of the careless and distracted manner piece. What I think Delegate Levine carried last year in the House was House Bill 426, and that was sent to courts and was left in courts. The second half of it about not being able to pass or attempt to pass on a bicycle lane, Delegate Watts carried last year's House Bill 308, and that was PBI to us. All right, any further questions of Patron? Anyone in the audience to speak in favor of Senate Bill 1550? Yes, sir.
Mr. Chair, members of the committee, Champion of the Virginia Bicycle Federation. As Senator Servo said, the trends are heading in the wrong direction. We think this would help get those under control, so we are in strong support of this bill.
Has the 2 feet to 3 feet made a difference?
You know, it has, and I've heard of a few cases where that's been charged, but I think also what he did mention is I think there's a great educational component to this, that people, as he said, are going to be aware that we need to share the roads.
All right, thank you very much. Yes, ma'am. Good morning.
Good morning, Mr. Chair. Sarah Taylor, City of Alexandria. This bill is support of the city as well as our Commonwealth's attorney. This fills a gap in current prosecutorial options. It gives, when people are not willfully reckless but careless and cause serious injury to someone. I literally almost got hit by a car on my way in here today, which was fantastic. But when people are not reckless but careless and cause a major injury in places like Alexandria, where we have lots of cyclists, lots of vulnerable road users, this is something that our Commonwealth's attorney believes would give him a tool in his toolbox to appropriately charge people in these situations. So we hope you'll consider it. Thank you.
All right, thank you very much. Anyone else in support? Anyone in the audience to speak in opposition to Senate Bill 1550? VSP, what saith thou?
Mr. Chairman, the senator was correct. He addressed all our concerns with the amended language, so we have no concerns with the bill as written.
All right, sir. Thank you. All right, if not, measure rests with the committee. Any further questions? All right. Then probably move the second of the Senate Bill 1550 be reported. Yes, sir. Delegate Horn. All right, it's been probably moved to second that Senate Bill 1550 be reported and referred to the Committee on Courts of Justice. Everybody go with that? All right. Members can vote on. I'm sorry. I just want to make sure that. All right. The understanding that staff has is that they do meet on Wednesday, but we're not sure if they meet on Friday yet.
They are normally scheduled, and we don't know if they're going to have that meeting. So would this go today, to a Wednesday meeting?
That would be up to Chairman Yancey, I think.
To do it on the floor.
Yeah. All right. And Delegate Laura.
I'd just like to comment to the patron. I would like to support the bill, and it sounds like a well-intentioned bill. I just can't vote for something that I don't really understand, and so I associate with the remarks from Delegate Thomas. And if it comes to the floor with the blessing of courts, I'll be with you. Thank you, Mr. Chairman.
All right. Everybody understand? You look quizzical, Delegate Watson. You good? All right. The members will vote on the electronic record to report Senate Bill 1550 with a recommendation to refer to the Committee on Courts of Justice. The motion to report and refer to courts passes on a 6-3 vote, sir.
When's full committee?
Thursday morning. I'd have a conversation with Chairman Yancey, Scott, just make sure that he's on board, you're on board, everybody knows where to go.
I got it. Okay, thank you.
Yes, sir. All right, members, I think that completes